Sawadika. In Malaysia, at this time of the day, we would be saying Selamat Petang. If you're Chinese, 大家下午好. I can't do Tamil, even though I have an Indian son-in-law. I think what I should be saying is Vanakkam. That should be about right. Let me start by bringing felicitations from the ASEAN International Arbitration Center, the AIAC, and to thank two very important persons here at the Thailand Arbitration Center, and that is His Excellency Mr. Suryapong and of course Mr. Nicky Balani. I think about 2 weeks or 3 weeks ago, when I invited somebody across the room in Colombo, Sri Lanka, a certain person by the name of Nicky Balani, I did not know that our journey was going to cross again. But I'm so proud and pleased that it has crossed again. Thank you, Nicky. I think that crisscrossing is completely illustrative of who and why we are here. Thailand, the Royal Kingdom of Thailand, and Malaysia, we are connected in so many ways, not just in our physical landmass, but that thin isthmus, but by the people. Just before I retired from the federal court, one of the decisions I had to render in the federal court was a decision about land given by Queen Victoria to the people of Thailand and Burma who resided in the island of Penang, so that they could continue to pray in a temple on that island. And the people of Thailand and the descendants from those original families continue to live in Penang and continue to pray in that temple that was given by Queen Victoria. Some of you may be familiar with that. And in yet another lifetime, I also had occasion to take part in a very unfortunate incident. Bunsom Bunyamin, who lost her lands because of fraud in Malaysia, and who went everywhere to find her remedy. But we finally found closure for her, and there was resolution. So hence, our roads and our lives will continue to intertwine and to meet. Ladies and gentlemen, thank you very much for this honor to speak with you and to share with you, more importantly, Malaysia's journey in statutory adjudication. Malaysia's journey in statutory adjudication was not in the least easy. It is not like what has just happened today in our country. I am sure amongst you are people who will have to go to the banks to talk about investments. You will not be only approaching your own national banks. You will be approaching other banks because your partners in your business venture would require you to gain confidence and satisfy the conditions of yet another bank. And very often, it would have been more than one bank, syndicated loans, etc. These are very, very common features. And because of all these ramifications, and because our companies have become more cross-bordered than we know, we have problems of insolvency. And we know that it is no longer a case that you need a passport to travel. Today, all you need is your handphone or your access to some IT gadget in order to ink a deal, isn't it? Does anybody ask a company, do you have a passport to travel? Do you have a passport to negotiate? Not in the least. And therefore, the companies have continued to prosper, and Malaysia recently then was faced with this problem of how to deal with cross-border insolvency. There is an ancestral model for cross-border insolvency, and that model was adopted by Malaysia within 6 months. Statutory adjudication in Malaysia did not have that 6 months. It was more like 16 years and more. I don't know what Thailand's journey has been. I am sure it has been challenging. Let me just share how ours has been those 16 years. I am responsible for that 16 years, for it to have taken that long. Why did it take so long? Why? When actually the community, and this is so important, the people who are responsible for bringing change to any country, to any economy, the construction industry, they are the game changers of any economy. They are the barometers of whether an economy succeeds or otherwise. We all know ASEAN is now at the 4th or 5th place in terms of how much we bring to the world economy. And that is going to change by 2030, that the ASEAN economies will move up at least 1 or 2 ranks. And that is only possible because of the construction industry. I remember watching the change in the legal landscape when the proposal to bring adjudication was first discussed. Amongst who? Well, the lawyers are the ones who are always very busybody, wanting to know what is the next change in business. For a moment now, can I just check with the audience, how many are lawyers? Hands up. Some of you. Can I ask how many of you are from the construction industry? There you are. Thank you. It is because of you that the lawyers have work. So do not forget. I recall when statutory adjudication was introduced in the United Kingdom back in the 1990s, how it was changing the legal landscape in the United Kingdom. Barristers no longer had to spend time in court in order to get their clients' money back in the pockets. And suddenly, lawyers or barristers were becoming almost judge-like because they had become adjudicators. Who are these people? Why have they now suddenly assumed roles and importance almost like judges? Is it because these lawyers don't have enough work to do? Or is it because they don't want to be judges or arbitrators that they have to have something to do? Well, maybe a bit of all, maybe none of it, depending whom we are talking with. But change, and it changed, it did. The construction industry in the United Kingdom saw a drop of cases going to the TCC, the Technology and Commercial Court. Why? Because of the advent of the Housing Grants Act, where adjudication was introduced for the first time. But adjudication is not new. Adjudication came from FIDIC. Adjudication came from the construction industry itself. But adjudication had to take a more formal and more frontliner role. And that was what happened under the housing grants mechanism. But it changed the landscape, and it frightened a lot of lawyers in Malaysia. Suddenly, if they don't know construction, they are not interested in construction, they are not interested in construction-related matters, would that mean that their livelihood would be affected? that they can no longer succeed as litigators in court, that they can no longer have as much business in arbitration. There were these doubts, and nobody was really answering them. And therefore, what would the lawyers then do? Resist. Easiest is, no, this is not the right thing for the construction industry. And therefore say, no, we already have enough. We already have arbitration. We have the courts. But what was happening in the Malaysian courts? And I can only speak about the Malaysian courts. No different from a lot of other legal systems, we practice in Malaysia common law, jurisdiction, jurisprudence. It took time, and it still takes time. Not only does it take time to go through the process, it also is a process that is never ending, depending on your choice, depending on the lawyer, and depending on whether you have money to pay the next bills. Why do I say that? Because after a decision, after a trial, regardless whose favor it may have been, whether it's for the contractor or for the employer, somebody is going to appeal. And because in Malaysia, there are two tiers of appeal if you start the case in the lower court, you have two rights of appeal. You go up to the High Court and then the Court of Appeal. But if you start in the High Court, you may end up in the Federal Court. How long do you think that process will take? I forget to tell you, at the Federal Court, it is not an automatic door. You will have to apply for leave to get through that door. Therefore, it is not 3 times you're in court, it's 4 times you're in court. And do you think the lawyer has only charged you 1 fee? I'm sure none of you lawyers in this room would think that you were going to end up in the Federal Court. It's your client's choice after all. It takes time, it takes money. And therefore, it was decided that something had to change. It was taking time, and the decisions that were coming out from the courts were perplexing because, truth be told, I'm still a lawyer, I'm not a contractor, I'm not an engineer, I'm not an architect, I don't have the technical expertise. I can teach myself or I can be taught by the experts, but I'm still not an engineer. Don't even ask whether it's mechanical or electrical engineering. I'm not an architect. And therefore, if I didn't have the patience to hear the matter, I can get it completely messed up. And if you go upstairs on appeal, the courts will never interfere unless it is manifestly absurd. That's a very high threshold for us in Malaysia to overcome. So with all these various conditions, it was felt that the very important community, the construction community, who turned our forests into cities, who built schools so that our children could learn, who built hospitals so that our sick can be attended to, who built offices so that you and I have a place to go and work for the daylight hours, and where the governments can govern and be seen to be government. Those people who put the structures, the utilities so that our waters are cleaner and our electricity is immediately available, and so much more. What was happening to their interests? They who went to the banks to borrow and borrow from more than one bank, and sometimes in difficult positions of negotiation, they were not paid. They were not being paid fast enough for them to roll into the next project, for them to be able to do several projects at the same time, for them to be able to take part in another project. They were suffering. And they, the construction community, remember I said, were the people who our whole economies depended on. Their voice and their concerns were last along the list. So enough was enough. Despite all the resistance from the legal community and within the communities of any measure, and also from the government, and I then at that time at the Attorney General's chambers felt it was enough because we had just amended the Arbitration Act in 2004, effective in 2005, felt there was just too much for the construction industry. We said no. But we finally heard the Construction and Industry and Development Board, the CIDB, and I believe in Thailand you have an equivalent body, together with the legal fraternity and the construction industry got together and they came up with a plan. They came up with a work plan as you would do for any project. And they decided to do a triple attack on the whole community so that we would all be convinced. What was the first thing they did after they said that the problem was the inability to be paid, whether it is for that same project itself or to move on to the next project? This legislation, at least in draft, was prepared. And so in 2012, the first of the triple attack took place. Legislation was passed. It's called the Construction Industry Payment and Adjudication Act, as Nikki mentioned it. We in Malaysia like to call it SIPA. And it has now become quite a frequent phrase to say, well, you got SIPA'd. The second attack that was launched was to get the judiciary on its side. And how do you do that? Remember I said that judges are not necessarily trained in these matters. And it was then persuaded through CIDB working together with the legal fraternity that a construction court had to be established. A dedicated specialist court had to be established. A court where the judge who is determining these matters must at least have the minimum understanding, expertise, and knowledge. The third was to actually take it off the ground, and we did. When the Chief Justice of Malaysia at that time called me at a dinner to tell me that he wanted to speak to me in 2 days' time, I remembered pausing. It's Friday tonight. Why would you want me to call you on a Sunday? Well, when the Chief Justice says you call, you call. And I called him, and he had just come off his golf game, and he said, we want to set up a construction court. What do you think, Mary? And I said, Chief, that's a brilliant idea. It's long overdue. And then he said, can you please think of somebody who may be appropriate to helm such a court and call me as soon as you can come up with the names. That was on a Sunday. On a Monday, at around 10:30 in the morning, I was sitting in court hearing a trial. And I had been passed up by my interpreter. Chief Justice wants you to call him back. I had to immediately stop proceedings, adjourn, go into my chambers and call my chief. And my question to him was, yes, Chief, what can I do for you? You know, Mary, I understand you are the most suitable person to be that judge in the construction court. And I recall asking him, who said so, Tun, Chief Justice? And he said, well, your brother and sister judges. They looked around and they say you are the most suitable. And let's pack, we are leaving for London on Wednesday. And we went to London on Wednesday in the middle of winter, and we had to look at the construction court at the TCC in London, and we borrowed some of the ideas and we implemented it. So I became the first construction judge, and guess what? On the day that court was launched, so did the piece of legislation that I mentioned, the first THAC, which was passed in 2012. It took effect on the 15th of April, 2014. You see, even though it took so many years to think of the legislation, and after it was passed, yet it couldn't come into force. Why? Because the courts were not ready, the community was not ready. And on the 15th of April, the final THAC took place, the court was launched. And then it fell on my hands and in my court to then interpret the law. About 5 years ago, I was invited by the TCC when they celebrated their 100 years. And they wanted to learn what is the practice of other statutory adjudication regimes in other countries. And I recall going to King's College and sharing with them Malaysia's experience. And I recall telling them this, and this is something that Thailand will have to think of. When you join the ranks of regimes or systems which have already adopted some statutory adjudication, which road do you want to take? How do you want your regime to be? Do you want it to look like the UK, New Zealand, Malaysia, Singapore, or do you want to have exactly only what suits Thailand, or not at all? And I recall telling the audience at King's College that evening that it was so easy for Malaysia to say, I will follow nobody, that we will have to make our own journey. But wisdom prevailed, good sense prevailed, and I went back again to what I started with. Adjudication is not for the lawyers. Adjudication is for the construction industry. They wanted an answer to their problems. Therefore, it is not a new problem. Others have found answers, and those answers have been accepted by the industries worldwide. Answers have been accepted by the financiers worldwide. Why would you want to change that? You can modify it. You can make it look better because of your local conditions. And of course you must, because Malaysia is not the UK. Malaysia is not Singapore. We have a completely different regime with so many other tensions. But surely some fundamental principles must remain the same. So what are the fundamental principles, ladies and gentlemen, that any statutory adjudication must have? First, it must be for your construction industry. This is where you should not share. It cannot be for construction and anything else, because your problem is special. Your problem is peculiar. It is the fact that you are not paid, and you are not paid fast enough, and you are not paid in full, and you are not being heard, if you are the employer, that there is a measure of LAD to set off that claim. And therefore, it is a highly specialized area that therefore requires a complete regime totally dedicated to the specifics of the industry. Secondly, it is an answer not for all time. It is some answer for the interim period so that you can move on, whether within the project itself or to your next projects, or until you move to the courts for final determination, or, as you have stated in your contract, decided in arbitration. It is supposed to give you an answer that the parties will respect and must respect as final for the moment until it is finally determined in arbitration or in court. It is an answer that you can hold in your hand while you are pursuing those remedies concurrently. And that's the beauty of adjudication. It is statutory in that the government recognizes it and gives it that force of law. But here again, let me pause for a moment. The adjudication regime in Malaysia has developed so much in the last 11 years that with the decisions given or meted out by adjudicators, the courts have said that you do not then have to go to court to obtain an order for it to be complied with. That debt or that pronouncement of liability to pay whatever the amount, provided of course it passes the insolvency limits, you can immediately present a winding up petition. And therefore, Malaysia is at a different crossroad now in that on the one hand, although the statutory decisions are intended to be of interim finality, contractors, employers, and just about everyone else are using those decisions to impress payment by threatening to wind up companies. And the winding up of a company is serious business, is fatal. There is no turning back after you've presented a winding up petition, because the moment a winding up petition is presented, last time I saw, most contracts would have said that is an act of default upon which termination can happen. That's an act of default upon which a bank may recall a loan. That's an act of default where performance bond or guarantee can be enforced. And yet, as far as statutory adjudication is concerned, it is only supposed to have interim finality and not permanence. So Malaysia is at that crossroad and it's trying to undo or at least to explain those positions that we have reached. Something Thailand may want to think about if you are seriously looking at statutory adjudication. What kind of contracts attract statutory adjudication? According to the Act, it is only to construction contracts. It is for the industry. But it is not for the personal homes. It is not for where you and I built a home or we renovate our homes and we employ somebody to do that project and we fall into disagreement. The construction industry CIPA Act for Malaysia is only available for corporate players. It is not available to Mary as an individual. It is available if it is Mary Incorporated. If I am a company and if the building that I built is more than 5 stories high. So, don't you see that as far as the Malaysian scenario is concerned, it was very clear that it is only available to the corporate players because it is for the industry. Secondly, the Act applies to everyone who is involved in the construction contract, provided they are in Malaysia. The project is in Malaysia. And this is important so that you can attend to the problem, you can conduct site visits. It will be quite ridiculous if the project is, let's say, in the United States, and the adjudicators will be flying in and out trying to sort out a dispute. So the territorial limits of the Act are important. The third point, as far as the Malaysian statutory adjudication regime is concerned, is that the government is not exempted, whether the government is the federal government or the state government. And why is that important? Here, I pause for the third time to say that the government asked for a moratorium of 2 years because the government had to get their contracts in order. But it is so important that the government is involved. After all, isn't the government the largest game changer together with the construction industry? Who builds hospitals? Who builds schools? Who built all these utility plants but the government, or somehow government related? And if the government projects were excluded from the application, you can't get your money. And who is the biggest money payer? The government. So the Malaysian government took charge and allowed itself to be involved. The last is the fact that after you've got this regime in place, we needed to train every user. We had to prepare the adjudicators. And who are the adjudicators? Not only the lawyers in the room, every one of you in this room who has technical expertise. In fact, ladies and gentlemen, the ones with the technical expertise are the better qualified than the lawyers with respect. Why? Because it is about payment. It is actually at the end of the day, the job of the quantity surveyor, the engineers and the architects who certify the claims. And therefore, it is the availability of dual expertise that will make you the best adjudicators. So Malaysia then had to train a sufficient body of adjudicators to then be ready to adjudicate. Who will appoint the adjudicators? It's another important consideration, and this is where, under the legislation, the appointing authority is the AIAC. And so the AIAC was then given a role larger than the one that it had hitherto been assuming office of. Under the Act of Malaysia, the AIAC is the appointing authority. But the AIAC, under the arbitration regime, is an intergovernmental setup. But under SIPA, the AIAC takes a role in the domestic scene because adjudication, after all, is only for Malaysia, within Malaysia. And it was then important for the AIAC to, after identifying that you need adjudicators, to then run the courses and certify adjudicators. And that we did. We ran modules, and until today, I will go shortly to the slides and show you what we now do. Adjudication is meant to be very swift. How can it be swift? It is handled by those who are only beginning to learn. They have to be experts. In the Malaysian regime, which is actually longer than the regimes in other countries, it takes about 3 months. The appointment process for an adjudicator takes 5 days, 5 working days. The moment a request comes in, I will have to decide who to appoint. And that decision has to be done very, very quickly. And a decision has to be rendered in the 90-day period. If an adjudicator falls outside the 90-day period, that decision is a complete nullity. Once a decision is delivered, the decision cannot be set aside except on 3 grounds, either of 3 grounds. First is fraud. Secondly is if there is a breach of natural justice. And thirdly, if there is an excess of jurisdiction. For the lawyers in this room, you, I'm sure, would be in a happy place because these are the familiar grounds that you would see under the New York Convention. But if there is no challenge to set aside, that adjudication decision will be respected and they'll be paid. Out of the so many cases that the AIAC has handled, I can very confidently tell you more than 85% of them are paid up and nobody complains. That's at least the regime now. At the very start, it was about 95%. I guess something has started to fracture, and it is what we have to attend to see and to bring greater confidence back to adjudication. But 85 to 95% of the decisions which are made and which are validly made within the 90-day period, they are respected and they are paid for. And If they are not, and if the matter goes to court on a challenge or for a stay, the courts, what's the court's reaction to it? The courts have an 85 to 95%, in fact, sorry, it's a 95 to 98% chance of upholding the decision of the adjudicator. And if it goes through the three ranks of the court hierarchy, that number becomes even tighter to 98% that the decisions are upheld. What does it say? For us in Malaysia, it is a success story in that it works. But I was told recently by some colleagues who practice in purely and solely in construction that the numbers of adjudication cases that we are getting are not good enough. So what have we done at the AIAC? Last week we had our Asia ADR week, but we ran 5 preludes before that ADR week. We took our adjudication and arbitration to the ground. We went to 5 regions in our country and we talked to them. And from there, we realized that we needed to do more. We needed to engage with the local community, the contractors who have problems trying to find a lawyer, who have problems trying to find somebody to explain to them in the local language how the adjudication process works. And therefore, we do have a lot more to do. So ladies and gentlemen, it has been a hard journey. When I had to sit in the construction court and decide on the very first case, and I had to give my decision, I took about a week to write my grounds. And the grounds were about, I'm told, it's about 90 pages long. I came out to deliver the decision. My courtroom was packed. It was only standing room like a concert. Why? People wanted to be there to hear the first decision. And it was a decision Malaysia had to decide. Follow UK, follow Singapore, follow anybody else, or was it Malaysia? At the end of the day, I remembered that it is for the construction industry, and I had to give them back consistency and predictability. It still had to be something that they were familiar with. The question that I had to face was whether this act was immediately available to everyone, or was it only available for contracts inked after the 15th of April. Who do you think, how do you think that decision should be? Hands up in the audience. I'm sorry, the ones who are joining us virtually, you can't take part in this. But those in the room, if you had to be that judge, and here's a piece of legislation providing for statutory adjudication, should this adjudication be available only for disputes, payment claims that arise after the contract was made, when the act came into force, or can it apply to even contracts made 10 years earlier? Those who think that it can apply to contracts made earlier than when the act came into force, can I have a show of hands? Okay, that's 1. Okay, 2 or 3 of you. Thank you. 5, 6. Thank you. It's almost like an auction here. Who thinks it should not be available, but only it should only be available to contracts made after 15th of April when the act came into force? Anyone? Yes. Well, let me see. It's about the same, equal. Ladies and gentlemen, I had to make that decision whether the act was available immediately to everyone in the construction industry, or it had to wait for the contracts to then be inked and for the contracts to fall into disputes. Well, ladies and gentlemen, I answered in favor of the user. For me, this is only a mechanism to try and get the money back, and therefore it should be available immediately. When your contract was inked is immaterial. So I made that decision, and immediately adjudication rose the claims that arose, it just shot up from 1 to 90 to 100 cases. It became the most popular flavor in any restaurant or in the courts. 5 years later, the federal court in Malaysia said I was wrong, by which time those contracts had already been expended and the contracts made on the 15th of April had started to take effect. What was done was done. But that decision of mine, wrong, so it speaks to by the Federal Court of Malaysia, nevertheless set our adjudication regime on an immediately steep curve. Suddenly, everybody found that this was the most effective remedy. I recently thought that there should be another aspect to statutory adjudication. Fine, you go through the whole regime and you get a decision in your favor, but the employer doesn't want to own up. What can you do? As far as the legislation is concerned, it's peculiar to Malaysia. You can suspend works, and there is nothing wrong with that. You are not in breach of contract. You can also, if you are the subcontractor or nominated subcontractor, you may go immediately to the employer and say, don't pay him, pay me. And you may therefore have direct payment. And we found that as being extremely effective. Will Thailand, if Thailand chooses statutory adjudication, choose that way? I don't know. It's your choice. What kind of construction contracts? I said it is all construction contracts. But is it for only progress claims? Malaysia decided to go as expendable as possible. We have allowed it to even for your time and expense, and we have also allowed it for LAD. Singapore has decided it should not be. It is more limited in regime. I understand the Hong Kong model is also going that way. Well, those are because of local conditions. Personally, I think we have gone far too far. It has become available to so many types of contracts that it is difficult to keep track. I prepared some slides, or a colleague of mine, Ragini, has prepared some slides, and I thought it should be and may be of help. You've just been listening to me. Thank you very much. But I thought you should have a look at what we have at the AIAC. This is the legislation, and we have, it's available on a QR code, and it has so many parts. Now, how to make it better work? We have issued circulars from time to time, and it guides you. Of course, by the way, the adjudicators will be paid. How do you pay? How much will you be paid? It is dependent on the value of the claim. We have issued, as I said, so many circulars that will guide. Adjudicators, arbitrators, everybody has a bad day. We then have a code of conduct to make sure that there is conformity and there are standards. So we have a code of conduct dealing with at least all these 8 matters. This slide shows you the whole process from beginning to the end, from the time when you make a claim and how it becomes an adjudication claim, how it gets to the adjudicator, and how it ends up with the adjudication decision. There you see on step 16. It's a process that is to be concluded in the 90-day period, and the decision has to be in writing. We have had decisions that are more than 100 pages long, as well as 3 pages short. How you want to write depends on style, capability, and I guess it depends to a large part on what the dispute is. This is important. How expensive is the process? Well, we collect administrative fees. There are 2 charges, basically, the administrative charges as well as the adjudicator's fees. Now, I'm sure, ladies and gentlemen, you are very familiar with the fact that when you're talking about fees, do not forget expenses. Those are your out-of-pocket expenses, and how are they catered for? they will be dependent on the actual expenditure and bills. This is the schedule fee. As you can see, they are in brackets. These are negotiable between the parties and the adjudicator, and they have to decide on those terms, the fee terms, inside 10 days. They can't sleep on it. And if they can't come to a settlement, by default, the schedule that is in our legislation will apply. And the most expensive fees really is about 50,000 Malaysian ringgit. You all like statistics. You like to see some numbers. Well, from the time it first started until today, our highest is just under 800 cases. That may not be much for Thailand. It's kept us quite busy, and it's been one of our mainstays because construction, arbitration, and construction adjudication is a busy business for the AIAC, and I have full respect for it. This year, for some reason, we haven't had as many, and I'm trying to find out why. We are down by almost 200 cases. I'm getting very worried, Nikki. Last year, we hit 635 even before the year ended. It was quite a good year. How much? How much before you want to take a dispute to adjudication? Anyone wants to guess what is our highest amount? Guess? Gentleman in the beautiful yellow tie. How much do you think it will be, the highest claim? And mind you, our claims are utilities, building of power stations, building our latest building of the Menara 118, second tallest building in Malaysia. So if you think about that, building bridges, highest claim, lowest claim, I'll show you. Look at the lowest claim, only 1,200 ringgit. And the highest claim is 306 million. So it can be any measure. It's entirely up to the parties. And look at the kind of figures. Most of our cases stay within the bracket of 300 to just under a million. Those are very popular brackets. And that shows how important it is. You don't have to be a multi-million-dollar claim before you want to take it up to adjudication. And that's the reason why we had a hard time trying to convince the Malaysian government to increase the fees. We're only going to be able to go up by about 10%. And that's as published. I can say this because the rules have been published. They will come into force. The new rules are going to come in force on the 1st of January 2026. But it was important that we kept the fees manageable for the parties who are already having problems not being paid. So can you imagine they still have to come up with money in order to collect money? Adjudicators, how many do we have? Up until the 7th of October, we have over 700. You may think that that's not a large number. Well, if you remember the number of cases we have per year, it's less than 700. I can't even give a case to every adjudicator. So frequently when we have conferences, the adjudicators coming up to me and said, "But Mary, I haven't had an appointment." Well, we haven't had the case. How am I going to build a case? And then I had one adjudicator send me a complaint that he has only received one appointment a year and he hasn't had more than one appointment. I looked through his records and I found that in 3 years, his earlier years, he had 3 appointments per year, and in the last 3 years, he's had 1 per year. Remember how many cases I have? Less than 700, and we have 700 over adjudicators. I thought we were being really fair to him. Thailand will have to decide how many adjudicators will be the right number. But repeat appointment is nothing wrong because they are your best adjudicators. if they are the ones that you can rely on, who have delivered consistently, and the industry is happy, and their decisions are upheld by the court, why wouldn't you want to have the same repeat adjudicator? There's nothing wrong. But my task is to try and spread it out as best as possible, subject to those conditions and observations. By experience, we have slightly more lawyers than we have the technical crew, but you can see that we have both. Male and female, unfortunately, not enough ladies, but we have both technical and legal. How do you apply to be an adjudicator in Malaysia? And it's something that I would like all of you in the audience to think about. There's so much that I said at the beginning, that we are related and we're joined. We have common interests, and your clients will be investing in both our jurisdictions and more. It is very important that you attend the course. We have yet to organize another course either this year or next year. And if that course comes open, you might like to consider taking that course first, because you do need to know the law. You need to understand the regime. We don't have to teach you the technical bits. We don't have to teach you how to decide whether a claim is allowable or otherwise. But we certainly have to familiarize you with how the Malaysian law and statutory adjudication works. We at the AIC have a lot of challenges administratively. What are those challenges? People don't want to pay. One side pays. We have the timelines that we talked about. We also have challenges trying to find the right adjudicator. 2 hours earlier today, I had a case counsel telling me there are 2 adjudications and they will like the same adjudicator. We don't have a power of consolidation, but we then have to find somebody who's prepared to do not just 1, but 2. And we've had occasions where we have 6 adjudications that come in at the same time, of different amounts, same project. Now I'm going to give 6 cases to 1 person. Unfair, but necessary because of the problem itself. We then also have to, our administrative challenges descend to matters of conflict checks. Multi-hatting. Lawyers who represent a claimant may tomorrow be the arbitrator for the claimant in another case. Are they conflicted? If they are not conflicted, they may be married to somebody who is similarly engaged. They may not be married, but somebody in their firm may be handling. So conflicts is a huge headache, but it is absolutely necessary and vital to get it correct. The administrative issues I mentioned is people not wanting to pay. It costs money. You have to pay up in advance. Like arbitration, I'm sure the THAC is the same. We collect in advance, but people don't want to pay, or they don't want to pay up in full. And sometimes after they have filed the claim, they don't like the face or the identity of the adjudicator, they withdraw. Well, that's their choice. So long as if they are looking to file again, we'll collect another set of administrative charges. I say it in that way, but really with respect, it's entirely their choice. There are legal issues. Those legal issues are being ironed out as to the extent of the claims. There are so many pressing problems in court. So how do we then make sure that our adjudicators and our construction community stays abreast? We hold workshops. Unfortunately, our workshops are on Saturdays, but I can tell you it is quite packed. The community is very interested, and no adjudicator wants to get it wrong. No adjudicator wants his decision to be set aside because they feel that it is a black mark and an indication of their incompetence. So there are legal issues involved, but what's important is that not just the AIAC, but the bar keeps everyone abreast on these developments. I indicated earlier, because of multiple claims, we have such consolidation requests and how to get everybody together. And that, I think, should be enough. I've taken so much of your time. I hope that has been beneficial. Malaysia's experience is not necessarily, as I said quite a few times now, the experience for education. We, however, have found that it has remedied situations on the ground. I do find, and this is very important, I find that as a result of the introduction of statutory adjudication, where there is no exemption even for the government, except our security projects, I must say, people are more disciplined, more professional, and more accountable. It is not 100%, but it certainly is more than 50%. It's a good start. It makes Malaysia a safer and better place still to invest and to stay invested. And it is important that we offer everyone every opportunity for access to justice, which is not necessarily in the courts or in arbitration, and that Malaysia and the legal system redresses and address what is a pressing problem, what was a pressing problem, and that is the fact that people were not being paid. And those people were very important people, our construction community, the people who did everything for us so that our community could thrive, and yet they didn't have a voice. For us, it worked because at the AIAC, if you ever come to our functions, and please do, you will see that the audience is not an audience of the legal community, but the audience of the whole construction community and more. And we listen. I leave it up to Thailand and to your wisdom to make those choices. Thank you very much. Kapungka.
Thank you, Your Honor, for such a terrific presentation. Sorry, actually I have a lot of questions because right now we are trying to push forward this legislation as well. But for the time limit, I will give myself very few questions. The first question is that back then, at the time when we deciding the model of the security and statutory applications in this case, if you look at the scope of the disputes subject to the adjudication, and I think you already mentioned that in my recent model, the scope of disputes are quite broad, or broader when you compare with the Singapore models or Australian models. So my first question is, why did you choose extend the scope of the disputes to an over more time of dispute? Because in Thailand we are sort of designing this issue as well. Because if you allow the employer to use it as well, then if they adverse effect, what an unexpected result that we want. So, and the second question, sorry, I will just speak. It's about the selection of the adjudicators. Back then, did you decide whether you would allow the payment and the respondent issues who will be the adjudicator? I understand there's some jurisdictions like Australia, on mission, they allow the parties to choose their own adjudicators.
Thank you very much. Excellent question. Can I answer the second question very quickly? Malaysia does, our legislation does allow parties to choose, and I rather parties choose because, you know, you can't get it wrong, right? If parties choose themselves. But very rarely do parties, they're already in fight. They can't even agree on who's right and who's wrong. You think they're going to be able to agree on finding that person? And I'll tell you what is a problem with finding that common person is who's going to pay. So, and it doesn't matter. The last one that I had just, was it last week? It wasn't a very large claim, but I thought it was so sensible. And they were not legally represented. So sometimes, again, with respect to the lawyers, I'm a lawyer myself, we complicate things. So yes, Malaysia has, under its regime, the option to the parties to choose the adjudicator. It's not done often enough. I wish it was. It cuts down all our work. The second question is...
What about if we have issues from the list?
They don't even have to choose from the list. They can choose anybody they want because it's party choice. At the end of the day, it's their dispute. They find the person who best decide. And it can be even the quantity surveyor who was supposed to have made decisions in the first place, or the architect. It's entirely up to the parties, but it's somebody whom the parties have confidence in. But having said that, in reality, I find that they pick somebody whom they have a lot of respect. Somebody who has gone through the grill rather than just the mill, and somebody who is dual qualified or who has been an arbitrator as well as a litigator. And so, unfortunately, that comes down to a very small window of people with that kind of expertise astride both arbitration and litigation. So it doesn't have to be from our panel of adjudicators. When we were, for your first question, I wasn't the person choosing that scope. That person is Justice Lim Chong Fong, who is now in the Court of Appeal. Chong Fong, when I asked him this question, I said, Chong Fong, you know, when I looked at the legislation, it really is only for progress claims. If you think back, it's supposed to be an interim remedy. Allow cash flow to come back so that you can carry on either with the project, a subcontractor, subcontractor, the deliveries. The deliveries 2 months ago, the adjudication claim that we had was not about the mortar, not about the brick and mortar. It wasn't about that kind of services. It was about supplying labor for the people who were going to do the actual physical work itself. So when I asked him, Justice Lim, and when I first read the legislation, and even now, my view is that it is supposed to be for the interim period so that you can move on. And the difference between Malaysia and other jurisdictions is it for your progress claims within the same project, or it can be for the final claim. And I recall my colleagues who were deciding in other cases consulted me for my view, and I said, hey, if I have already thought of this as being a mechanism to resolve a dispute, surely it should not be only available for a small class. It should be for the widest class. And so I then said, final claims can also lah. So it then expanded to final claims. And from then, so final claims are not your temporary problems. Final claims, your project has already closed and you've moved on to many, many other things, and yet it's available. And the problem with that is that temporariness is not there. So that's the reason why for Malaysia, although the words used in the Act is for work done or services rendered, therefore, it must be something already done. It seems to fit in for your final claim, but for your LAD and for your loss and expense, that's not for work done, services rendered. It's something else, isn't it? And your loss of profits. Surely that cannot come under adjudication. And Singapore is very clear. No, you can't, because it's not work done. But how we have read it is, let's be generous, let's allow it. And the problem with doing that is, again, back to the temporariness that I was talking about. It doesn't seem to fit, but that's the direction and that's the interpretation given by the courts. And how have we tried to remedy that? Well, unless we introduce amendments to the legislation, we have tried to engage with the judiciary. They attend they run our workshops as well. They are part of the workshop. And then they listen. They listen for themselves, the reaction on the ground, and the problems that then are faced, not just by the contractor, but by the employer, who are heavily invested in these matters, how it doesn't seem to work with them. So when you want to introduce legislation, make sure you look at your end. Look at the ramifications of your decision. Remember, I mentioned about insolvency. It doesn't make sense. But that is where we have gone, and we are still trying to navigate, the word is navigate, to see that we reach somewhere where both, not just the subcontractor, but the contractor, but the employer is also happy with the outcome.
Thank you very much for the presentation. It's really nice. You can see to this one.
Thank you.
And I have a question. Just to clarify, you mentioned that the arbitration does not include the loss of extending the LD and the extension of time claims, right? But normally the final claim sometimes mixed with the owner or the LD and not pay the LD. And then unless the contractor proves that the project were delayed by the owner or the owner. So the final claim then somehow is related to the delay acceleration.
Yes.
So I wonder if these adjudication systems will include considering those claims as well, or it's just the payment?
Unfortunately for Malaysia, it extends to that. The variation claims would be for your work done. Your services already rendered. So variation claims are quite common, and it appears in a progress claim as well as in a final claim. The point I wanted to make was that the decisions that have come out from our Malaysian courts are so generous in the sense that it allows these claims. The only one that I have seen not allowed at this point in time is loss of profits. It's quite clear. But they have already started allowing even for loss and expense. And that's that little worry, because it doesn't seem to sit easy even for a final claim. But that's where we are. It has been allowed. It doesn't sit comfortably with the community, but that's what we have.
My name is Tu. I'm currently president of the THAC. Nice information about you. I have a question of maybe I refer to your statistics that you mentioned that you are one and the latest year that we have less cases.
Yeah.
I have some proof for that.
Thank you.
Because we make for the two jobs.
Oh,
so there will be more and more less cases. So you have 704
adjudicators, yes.
of them we lost jobs. Okay. My question is related to maybe you can share your knowledge or experience that you know that it has the cost of the dispute avoidance and adjudication, right? So I would like to see that how you see that your adjudication system compared to the cost, and I believe that we are going on a different path or journey. Maybe you can share your.
Thank you, Mr. President, for that wonderful question. Thank you very much for suggesting that perhaps the numbers have dropped because things are okay, people are paying, they don't have to go. I will put that in our annual report. Thank you very much. And as far as our 704 adjudicators are concerned, we're actually cleaning up that list because we do have people whom I think are no longer interested, who may not have come up to the mark, we do have to clean up that 704. That is not to say that you all should not take up the course, but do consider. As far as costs are concerned, costs are very important. I can only, Mr. President, answer in relation, in relativity. Remember I made the remark about costs in litigation. And this actually is an answer that I would make in relation to arbitration costs as well. That at the end of the day, when I look at company books, litigation costs, particularly for a public listed company, you first of all have to declare the fact and you have to inform your shareholders and anyone who is interested in investing in the company that you are in dispute. So until you write off that debt, you will have to continue. But realistically speaking, when I look at the costs and compare that in any general company annual report, costs of arbitration, costs of litigation, costs in recovery are actually a fraction of the cost of the investment itself. And that is anything from 2% to 10%. But it is a very important estimate because it comes at a time when a company is stressed. And that's when your 2%, 10% becomes suddenly so much more. So I actually don't think cost of litigation, cost of recovery, cost of debt recovery, cost of engagement in litigation, or even in adjudication as astronomical costs. They are necessary costs, but in proportion, and one has to look at things proportionately. They are really fractional. And the accountants know how to report for the following year. Having said that, and that was the reason why our amendments took a longer, we had already recommended, I came back after my retirement from the judiciary, or in fact before my retirement, I was approached by the Malaysian government to assist in the reform work for the Asian International, for the AIAC, and in particular to put into place, remember I said, I'm appointing, so I have to decide. It shouldn't be I in one person. That's not transparency, that's not accountability. And therefore, the AIC has decided that we must reform. We must form a court of arbitration and therefore have greater accountability and openness in the process. We completed the work December last year. It has taken almost 10 months for the Malaysian government, particularly the Public Works Department, to be convinced that the increment in the cost of adjudication was justified. It took a long route because the Public Works Department and the Malaysian government was very concerned with the implications to the whole cost of construction itself. And it finally agreed on a marginal increment of 10% because we had to keep adjudication still as a viable choice rather than to go into litigation or to go into arbitration. And we have seen it coming and producing good results. But I am also conscious that, remember I showed the lowest claim is 1,002. We do have very large numbers in the under above 150,000, but inside a million. That's a substantial volume of our cases are in that bracket. But it is the ones that don't make into the bracket, the 1,200 ringgit claims that I'm worried about. And it's something I haven't discussed with the Malaysian government or with my other colleagues, and that is to provide adjudication on a social level. Some arbitration institutions around the world do social arbitration in the sense that it's from the administrative charges that we've collected, we give back and we help fund these kind of claims. I'm a little bit concerned about doing that because it almost seems as if I'm conflicted. One hand, encouraging and running administrating and adjudication, and on the other hand, funding it. So we'll have to look at it, but I think it is very necessary. So to answer your question, Mr. President, I don't think the adjudication costs are prohibitive. It is a figure, or there were figures and a scale that was reached after the assessment, the market survey had been done. But what we have, however, allowed is parties to go and negotiate on costs other than the scale. If they think that the scale is either too high or too low, they will have to find their own water level. I'm not sure, Mr. President, if that answers your question, but they are real concerns. Thank you.
Good question. Since I'm in charge of Asia and one of the countries is Malaysia, so I never heard this kind of scheme coming from my member association named Association of Consulting Engineers Malaysia before. So that's why I'm curious that why I didn't hear this before. It was more than 10 years, right?
11 years. And I have so many engineers on my adjudication board, and they are fantastic. They make fantastic arbitrators, and they are fantastic adjudicators. I have written a judgment to say that the best adjudicators are not the lawyers, because we have to learn the technical part. It is the technical people who are best positioned to crunch the numbers and to know whether a variation, an EOT ought to have been given, how much EOT, and then all the other variables. They know, because this is their whole bread and butter. The lawyers will have to learn. They are the first person, so you're qualified, Mr. President. Yes.
They only require 7 years.
Yes, 7 years.
Any other questions? Otherwise, we'll take it. We'll take. Anyone else has any questions? We'll take them together. That's the last set of questions. Okay. Then we'll take the last question.
Thank you. Just a quick question. I wonder if the party did not follow the adjudication, what would happen?
Thank you very much. That was something if they don't, well, so the decision is against them and still don't pay. So what has happened is winding up, because it's only corporations. Adjudication is only available to corporation souls. It's not available to the individual Mary. It's only if it's Mary Inc., then yes. So I can be wound up. But winding up, sometimes the courts don't want to wind them up. They understand that this is only temporary finality, the arbitration is going on somewhere else. But here you are, you've got a decision, 5 million in your favor, and you can't get your money. I recently thought of this together with another lawyer, CIDB. All contractors have to be licensed. All employers have to be licensed. And you have to renew your license every year. You're not going to get your renewal like your car license. You can't renew if you've got too many speeding tickets or parking tickets, right? So why can't we do the same for the construction industry? And it's something I've been thinking of very seriously, that the only last way is licensing. If you're not licensed, you can't approve. You can't submit, you can't tender. So perhaps that's the way. I'm sure as I speak, and I think this is on the waves, I hope I can get home to Malaysia. They may be so unhappy with me with this suggestion. But I think, thankfully, the recalcitrant are very, very few. I'm happy to say. The few sometimes make it sound so bad, but it has not been that bad to make adjudication a failure. On the contrary, it is a success. And as you see, the numbers are coming down because perhaps the whole culture has changed. Thank you.